I'm Pam Masters, and I'm a collaborative family lawyer, which is to say that I'm a settlement specialist. I guide couples and families on the difficult journey of divorce without court involvement, sometimes without lawyer involvement. I do this in ways that protect children, preserves financial assets, and creates healthy co-parenting relationships. Today I'm going to talk about how alimony works in Florida. I hear so many common misconceptions about alimony. Among them, one, that there is a formula that the court will apply to determine the amount of alimony. There is no formula in Florida. Two, that incomes will be equalized by a support award. That is not the goal or purpose of alimony. Three, that who's at fault in the divorce, which usually means who had an affair or has a drinking or gambling problem or anything you can imagine, that would affect whether or not alimony is awarded and the amount. It doesn't really. In Florida, there is no formula. There's a national organization that promotes a formula, but this has not been adopted in Florida. In Florida, support is based on need of the recipient and the ability to pay of the payor. Both need and ability to pay are figured out by looking at what we call a financial affidavit. This is a court form. It's really just a giant detailed budget that every divorcing couple must sign under oath and file with the court. If one spouse has a deficit and the other a surplus, and a support award would otherwise be appropriate, then the court may award support. What do I mean by a support award would otherwise be appropriate? Well, there are so many factors. The judge has a lot of discretion in this area, which is why it's very dangerous to leave it up to the judge to decide. Some of the factors are listed in the law. Here's what the law says in Florida about alimony. In determining a proper award of alimony or maintenance, the court shall consider all relevant economic factors, including but not limited to the standard of living during the marriage, the length of the marriage, the age and physical and emotional condition of each spouse, the financial resources of each spouse, including non-marital assets and liabilities to be distributed. When applicable, the time necessary for either spouse to acquire more education or training to enable them to find appropriate employment. The contribution of each party to the marriage, including services rendered in homemaking, child care, the hardest job in the world, education, and career building of the other party, and all sources of income available to either party. In addition, the court may consider any other factor necessary to do equity and justice between the parties. Again, very broad, very ill-defined ideas here. The statute also gives guidance on the length of alimony, and it's based on the length of the marriage. So in Florida, there are short-term, mid-term, and long-term marriages. Short-term marriages are marriages under 7 years. There's a presumption that there would be no support awarded in those cases. Mid-term marriages are 7 to 17 years long, and there's no presumption for or against support in those cases. And long-term marriages are marriages over 17 years, and there is a presumption that a support award would be appropriate. In fact, a permanent award would be appropriate. But again, these are presumptions. Presumptions are made to be overcome. There are plenty of cases where a short-term marriage has resulted in an award and a long-term marriage has not. This is an awful discussion, an awful process in a traditional litigated divorce. Here's what happens. If you are the one seeking alimony, your every expenditure is questioned and analyzed, along with whether you're working to your full capacity and earning potential. If you are the spouse who is going to be paying the support, the same thing happens. Your expenditures are analyzed and questioned by the other side. They try to get your expenses down so you have more income to pay support. They try to find additional income so that you have more income to pay support. All in all, it's a humiliating exercise done in front of total strangers where you're left feeling like you have to justify your life and your worth. And it's not at all a good way to do what is a very difficult thing to do. And then again, the judge has complete discretion to make an award, the amount of the award, the length of the award. It's horrible. In a collaborative divorce, the support conversation is totally different. The focus is on both partners being okay financially, And the conversation is not limited to monthly expenses, but can include considerations of things like future income, retirement, savings goals, and college expenses, none of which are relevant in court. Some of which, like savings, will just be completely disregarded as irrelevant and unnecessary. As always, I'm happy to speak with you personally if you have any questions about alimony or any other aspect of collaborative divorce, divorce coaching, or mediation. I can be reached by email at pam@masterscdc.com or by phone at 386-271-8044.